Non-competes.
Yes.
What's the point, I suppose, of including them, the obligations of non-competes in contracts if they're very hard to impose?
Yeah, I mean, that's a very pertinent question, because just of late there have been some case decisions, even a case that went to the Court of Appeal, where the franchisor was held unable to enforce the post-termination obligation on the franchisee not to compete.
Yeah.
And that one sent shockwaves through the franchising community, because the non-compete had been drafted in fairly common form. So it did set hairs running that obligation had been held to be unenforceable. Now, my view on this is, it isn't just that recent case.
Yeah.
There have been a trail of decisions over the past few years, leading us to the point of me concluding that the days when you could draft unreasonableness into franchise agreements and get away with it has gone.
Yeah.
Now, I'm not saying you shouldn't bother with non-competes. In fact, quite the reverse. I think non-compete obligations in your agreement are extremely important, because they go to the subject of the protection of your system.
Yeah.
If you teach somebody how to run a system and then the agreement comes to an end and they can immediately go off and replicate elements of that system to run a business that competes with yours, that really does damage the franchisor's business.
Yeah.
So you have to be able to reserve your right to prevent that.
And surely that would come under reasonable, would it not?
Well, here's the thing. So the basic principle of this is that non-compete clauses in agreements, particularly ones that relate to the period after the agreement ends,
Okay, yeah.
only can be enforced to the extent that they are considered reasonable in all the circumstances.
Okay.
Now, that can include a whole myriad of things. It can mean reasonable in terms of the length of time. So, for example, anything longer than a 12-month ban on competition after the end of the franchise agreement, you're very unlikely ever to be able to enforce it. It also relates to the jurisdiction, the particular territory in which they're not allowed to compete. It relates to how you describe the services or the products that they're not allowed to be involved in. So there's a whole load of issues that you have to think about in terms of the drafting. But there's an even broader topic that comes out of these recent decisions, and that is, I think in this most recent case, there was a spotlight on the fact that the franchisee in question was only a plumber, and he had been a plumber, I believe, before entering into the agreement. The agreement was very long, very complex, would have been quite appropriate if you had a network of corporate franchisees who were all big players and there was parity of bargaining position. But in this case, there wasn't. So I think, although not all of these points would have been directly relevant to the decision, which was purely on, to the extent we're talking about now, purely on relating to the enforceability of the non-compete, it's clear that the judge was influenced by the fact that the franchise agreement, on the face of it, was patently unreasonable.
Right.
And therefore, I think for me, yes, the drafting is important, but you've also now got to think, in the circumstances, is all of this legal drafting actually appropriate and proportionate in relation to the particular system I am running?
Yeah.
Now, there's no one-size-fits-all answer to that. It may be or it may not be. But as I said at the beginning, I think the days when you can just assume, okay, I'm going to put every single unreasonable clause I can think of into this agreement on the basis that I'll get away with it, I think increasingly you might find that you won't. And there are just two, without going into all the details, there are too many recent decisions that are starting to point in this direction. So I think we have to do a bit of a sea change in how we're trying to approach legal agreements.
Yeah. And is there anything in particular that you did or have done in your agreements as a result of them?
Yes. So I'm always looking, every time I do a new franchise agreement, at how we draft the non-competes. and how we draft all the other clauses. With the non-competes, I'm being increasingly careful about the duration of the agreement, the duration of the non-compete, the level of experience the franchisee will have had already before they come into the franchise, and the extent of the products and services that we're saying that they must not be involved in.
Yeah.
So every single time I look at it with each franchise business individually.
Okay. And it's amazing though how some brands, and I've worked with a few of them, that have non-competes in particular sectors of food, but then you go to travel hubs in particular airports where you'll have one operator running multiple brands that on the standard agreement wouldn't have been able to do that because of the non-compete. But obviously they have a slightly different rule when it's maybe travel hubs or airports or...
Yeah, I mean, you're right. And that plays into the point about thinking really carefully about who your franchisee is. And it's very easy for lawyers to make the mistake of just churning out the same agreement or the same clauses for everybody. In the case you're describing, in all probability, the franchisee is themselves a major corporate with lots of different business interests.
Yeah.
They therefore have parity of bargaining position to a greater or lesser extent.
Yeah.
And then there are practical issues, if you're looking in an airport context, where the issue of non-compete just simply doesn't make any difference to the franchisor.
Yeah.
And if it doesn't impact in reality on the franchisor, they're not going to be able to enforce it anyway.
Yeah.
But again, I stress you have to look at each franchisee profile individually to make those kind of decisions.
Yeah. And do you get almost a good leaver and a bad leaver? So if someone's been terminated from their contract, do you maybe view that differently to someone who's come to the end of their tenure of their contract and then moved on to do something else outside of it?
Well, yes. In some cases, there is a case for drafting those situations differently.
Okay.
So that you say, for example, that if the franchise agreement ends for whatever reason within a short period of time after the franchise agreement was signed, that the period for enforcement of a non-compete could be shorter, and you wouldn't try and make it as long as 12 months. So there are some arguments about that. But more generally speaking, I think the wider subject is, okay, for every franchisor, they need to think carefully about the extent to which they need non-competes, particularly after termination, non-competes to protect their business.
Yeah.
Where they decide that theoretically they do, then they have to be drafted the absolute best way possible. So I would never tell anybody not to bother, except in circumstances where the commercials are, as you say, such that it just isn't important. But once you have got that provision in your agreement, the decision for each franchisor to make each time there's a termination is to what extent is it worthwhile for me to pursue this franchisee for breach of a non-compete. So to take two extreme examples, you've got somebody who's performed for a long period of time in your system. They've gleaned all your know-how. They maybe have got themselves a customer base, and either at the end of the agreement or before the end, they've started building themselves up to run a directly competing business. They already have access to your network of customers, suppliers. They can do real damage to you. Now, those are the circumstances under which you need to have a robust non-compete clause to fall back on. Another example, the franchisee hadn't been in the system for long. They were useless. They did nothing. They generated nothing in terms of sales. The agreement then ends for whatever basis, and then you hear they're running after setting up a competing business. The question for the franchisor, and it's my client's decision, not mine, but it's a question I always ask, is it worth it? Is it worth pursuing them? If they were useless as a franchisee, how on earth do we think they're going to do any damage to us as a sole trader? It's harder being a sole trader than being a franchisee. And then in some of the recent cases where franchisors have no doubt thrown an enormous amount of money at pursuing a franchisee, and then they don't win, they may retrospectively be ruining the day they ever thought of going down that route. But that's definitely a million miles away from me saying don't
Yeah.
bother with non-competes. They are absolutely crucial. You just have to be really careful.
Yeah.
And even if you're making a difficult decision, should I enforce this non-compete or should I not bother? It helps you a lot if you have got a robust non-compete you can fall back on.
Yeah.
If your non-compete was rubbish, you don't have the option to think about it.
So reasonable is the key.
Reasonable is the key, and careful is the key.
Also, would it make a difference if it's a unit-based franchise and then they debrand because it's come to the end of their time or they have been exited and they set up the new competing business in the same location?
Yes. Now, that, if you've drafted your agreement correctly, should always be easier to enforce than a man in a van type proposition where the franchisee can be going out to all number of different places and setting up or carrying out a competing business. That is certainly if you're talking about restaurants, then there really is a risk of the franchisee taking away your customer base if they do that. So that may well be a circumstance where, after due and proper consideration, we all make the decision that commercially, yes, it's worthwhile, and the money has to be spent for the sake of protecting the brand, not just for you as franchisor, but for the benefit of all your other franchisees.
Yeah, and that's an important one actually. Everything around franchising is supporting each other. So the franchisees, are important and they need to be represented. I suppose,
because if your brand gets trashed, it's harder for you to recruit franchisees, and it's harder for your existing ones to make good money.
Yeah.